All right, the Court of Appeals Division 1 is now in session.
Thank you, folks. Please be seated. Thank you. Good morning, all.
Judge.
Honors.
I am Judge Furuya. To my right is Chief Judge Goss. To my left is Vice Chief Judge Howe. And we are here for oral argument in our case number CV24-0434, Schnurr et al. V. Banner Health et al. As you may know, we record and live stream these proceedings. So please give your name before you begin your presentation. You have a maximum of 20 minutes per side, although you are not required to use all of that time. We do require you to keep track of your own time, so if you would like to reserve any time for rebuttal, just know that the number in the clock is inclusive of any time that would remain for that rebuttal. And it's up to you to keep track of that. Please keep in mind, we have read the briefing, we have studied the record, we have discussed this case in conference. And with that, you may proceed.
Thank you, Judge. Good morning, Your Honors. I'd like to actually reserve 10 minutes for rebuttal. Your Honors, I don't want to repeat the briefing, and I know you just stated you've reviewed the briefing, discussed it in conference, but there's a problem, I think, in the lower courts understanding case law and the precedent that exists here in Arizona. While this appeal was pending, the same defendant on almost identical briefing under nearly identical facts with my co-counsel Zahir Shah as the plaintiff's attorney in that same case, case called Ward, was decided against a finding of or in favor of the plaintiff, and that the issue of whether there was a parent agency would go to the jury. So, and I think that's obviously, in my view, the right opinion.
So, counsel, is your main argument, your primary argument, a parent agency?
It is, Your Honor, and I think the briefing sort of flip-flopped those a little bit, but I think ultimately we found and believed that the Barrett decision would apply either way, and it didn't really matter because the consideration really is the totality of the circumstances. In almost all situations, regardless of the theory before the court, when it is up to, when you need to look at the circumstances, fact-specific analysis to make a decision, generally speaking, those decisions are reserved for a jury, a fact finder.
The record seems clear, and of course I could be wrong, but the record suggests that your client understood that the doctor was working for EPS and not Barrett. At least that's what the paperwork shows.
Yeah, Your Honor, I would respectfully disagree. I don't think there's anything that would allow anyone to determine that that was clear. In fact, the agreement that she signed doesn't say that the emergency room physician is in fact an employee of some third party. It says that generally speaking, these doctors are not employed by the hospital, which leaves open the possibility that they may in fact be employed by the hospital. But I also think there's a deeper issue here if you're looking, especially in the setting of an emergency room, to allow someone in duress facing a life-threatening, in this case, was in fact life-threatening, and it did end her life, in agony, in pain, to expect that person to say, never, hold on a second, I need clarification. Is the physician who you're appointing to me your employee? And to expect these patients in those situations, or even if they're not in life-threatening situations, to even understand the implication of such a distinction.
So you're saying there's no way the hospital could avoid liability then?
Oh,
I don't know how you would do it, because you're saying they're in a life-threatening situation. How could you ever expect them to understand?
Well, so first and foremost, I think the hospital would need to do more than just put it in a document in the ER room. They would need to hold themselves out in their marketing and then in their advertisings. They market themselves as a place to go to the community. Come here in your life-threatening situations without ever saying, and oh, by the way, the doctor who will see you, they've got their own separate insurance policy. They're not employed by us, and you'll have to deal with them in the event of an error.
And so just to clarify the argument you're making to us, I take it you're not saying that there absolutely was a parent authority, but that's an issue to be determined at trial.
Well, if the court were to look at the facts and the test that was set forth in Barrett, which has been a precedent in this state for decades. I mean, I don't need to quote it for the court, but they provide the ER facilities and the equipment and the nurses and the staff. They promulgate the rules and procedures to be followed by the physicians group. I mean, we're dealing in Barrett with almost identical facts.
But we can't make those findings. That's for that's to be resolved at the trial stage, correct?
We would agree, but there is no dispute that the vast majority, the only dispute is whether the hospital set Dr. Eister's time to be at the facility. But all the other facts that were identified in Barrett are undoubtedly the same. They are Banner nurses, Banner ER facility, Banner staff. In fact, a Banner cardiologist had to approve the prescription.
I'm going to interrupt, counsel, because I understand your argument, and I understand, and several times you've now told us the facts are the same. The challenge with Barrett is an apparent authority case, but it applied an actual authority test. What is the test in Arizona that you ask us to articulate? Because it can't be the Barrett test. The Barrett test is actual authority. So what's the test that you say we should adopt, and what case do we look at to adopt that?
Well, so Your Honors, I would argue that the law is whether an independent contractor is in fact an agent of the principal is a totality of the circumstances analysis.
You're saying actual authority then is in fact. Apparent authority is they're not in fact, but there's an apparent authority.
Well, Your Honors,
so what is the test for apparent that is different from actual?
You only need to look at this state follows the restatement second of agency. If you look at section 267 and the comments to 267, the illustration to 267, it's even less clear. So the illustration to 267 is a shop owner. And I'll just read from the restatement second. The illustration, a department store contracts with T, an independent contractor, to provide medical care to its patrons. A patron walks in and the independent contractor, medical provider, provides care, but by mistake poisons that patron. Principal is responsible under those facts, and that is not even in an emergency room setting, right? This is a shopkeeper or a department store having an independent medical staff, medical provider on staff.
So you're saying that there's no way for the hospital to avoid liability because the doctor is in their emergency room. Therefore, what do we do?
So Your Honors, I would say that Banner could do a lot of things, and I'm not saying there's no way for them to avoid liability.
So what is the test? That's the problem. You're not articulating a test. What's the test under the restatement that you're arguing?
Well, I don't know that there's been an outward test that has been set forth, but I do think this court can make a test and can use whether apparent authority, Your Honors, is what does it outwardly appear to the person who is getting the care. And if you conceal all separation, all independence of this alleged contractor.
Let's not say concealed, because and I believe this was in the briefing, the defendant's position is that the only evidence in this record of an actual statement regarding that, any representation, is in the admittance documents, which say that generally ER docs are not employees of Banner. So, and I know you're glossing that, but to me, the word generally means generally. It means in most circumstances. So,
well, Your Honors, that would be the first step. Don't be vague. Be direct. This doctor is not our employee. Why say generally, other than you do not want to raise the question?
Well, but you can have generally because there may be a case in which the physician is, and they don't want to preclude that.
Then swap out the forms. There's no reason to use vague, ambiguous statements in your admittance documents. And I think there are way broader implications and consequences to allowing a hospital to pass off the cost of medical malpractice to a third party who isn't sufficiently doesn't have the sufficient assets to cover the harm that they can cause.
Any evidence in the record that's the case? I mean, this is an argument that's not anywhere.
Well,
I'm trying to argue now that we should, as a matter of policy, restructure how this works.
Well, I think we did make a public policy argument as to why allowing the hospital to pass the buck to an independent contractor would be against public policy. It would harm the Arizona public, and the court should consider. And I think the court can consider the fact that Arizona voters rejected an attempt to put tort reform in place in 1994 and then went on to codify in our Constitution that you cannot limit damages, but that is effectively what they're doing.
Counsel, I appreciate your argument, but we're not in the business of public policy. We're in the business of applying the law. And the law here is that Banner will be responsible if the doctor is an actual agent for take that you're proposing that, or that Dr. Aister is the apparent agent, and that's what I'm interested in. And I would like to know what the test for being a parent agent is so that we can differentiate between the cases where there is a parent agent and where there isn't. And I'm not hearing that.
Well, so first and foremost, I do believe that the totality of the circumstances test for actual agency applies. It applies here, and we do believe that he was their agent. Again, let's step aside for a moment from the apparent authority argument, because in the Barrett test, if we applied them, the vast majority of those do apply here.
I don't know that I agree with you, counsel, because in Barrett, wasn't that anesthesiologist an officer of the hospital? Didn't he lead the department? Isn't that why it was an actual agency situation?
There's nothing.
This doctor doesn't hold any offices inside of this hospital. Isn't that not correct?
There's nothing in the record that would suggest that, Your Honor.
Okay. And
And
so
the
he's
hospital
not.
wasn't there to do any of the billing, I'm sorry.
Yeah.
No billing. That was also in Barrett, right?
You mean,
That was,
that was big. The test that is outlined in Barrett, I think we've outlined all of the factors that the court considered, and the only factor, and correct me if you think I'm wrong, Your Honors, the only factor that I think even the defendant really tries to argue is, well, they didn't really control when Dr. Eister himself, he personally would show up to that hospital, but the schedule in which his physicians group would place doctors there was promulgated by Banner. And so that is the only factor in Barrett that might weigh in their favor. But that's when you have to look at the totality of the circumstances and say, why is this lower court deciding whether there's actual authority here? That's not a place for the court if you've got all of the other factors, which include, like I said, They provided the ER facilities and the equipment and the nurses and the staff. They promulgate rules and procedures to be followed by the physicians group in treating ER patients. The plaintiff does not have an opportunity to choose the physician who will care for them in the emergency room. That is sufficient evidence to support a finding of vicarious liability. That was Barrett for actual agency. That, on the issue of actual agency, should have gone to the jury in this case. I can respectfully, disagree with the court, with this panel on the issue of whether that should also apply to a parent agency, because in my view, if you have all of those things, if you have all of the things I just identified, which would potentially give you actual agency, then how
does that give you actual agency? Actual agency, as I understand it, correct me if I'm wrong, is the ability, the kernel of actual agency, the touchstone of actual agency is the ability of the master to control the servant. That's why there is liability for the master, because the master can tell the servant how to do, when to do it, what to do, in what manner, in what place. What evidence in this record says that Banner could tell Dr. Alster any of those things?
So, Your Honor, I would say I respectfully disagree on the issue of that requires the master to tell the doctor how to do it. I think that's precisely, it is not how, but what. That Banner could tell them what to do with their prescriptions, which means they had to go through a Banner cardiologist for approval in this case. Whether the doctor, while he was on staff, would see the patient. They controlled his actions, his conduct, what he did while he was in that emergency room. They did control it. They're not allowed to step into the shoes of it. They
control the doctor. So they told him what procedures he could do, and they tell him how to diagnose people and what ways they could diagnose them. They could, because this is a misdiagnosis case, right? So the Banner had some means of controlling Dr. Alster's ability to diagnose this patient.
So I think Your Honors are maybe, and I agree, it's difficult dance here, right? Because doctors have to have independent medical judgment. And so no hospital, whether he was the agent or not, could tell, whether he was an employee or not, could tell Dr. Alster some of those things, because it is within his medical judgment. And that's something that a non-physician can never really interfere in.
Can this hospital, is there evidence in this record, or question, where in this record does it say that Banner Hospital can fire Dr. Alster?
Well, Banner controls who enters their facility, Your Honor. There's no dispute that Banner could prevent Dr. Alster from working at Banner facilities. They could prevent any doctor from working. Of course. Under his own contract between.
Show us Banner retain that?
So, Your Honor, to allow.
Contract in the record.
The contract between Banner and Emergency, I think it's EPS, is not in the record.
Neither are the advertisements you kept talking about, are they?
Well, if there is a contract in the record,
I'm saying a couple of things are missing from the records that you talked about. I just wanted to kind of go back and cover the advertisements that you kept talking about also aren't here.
So, Your Honors, I do think the court can take judicial notice of the fact that these hospitals all, regardless of locale, advertise themselves out and hold themselves out to the public. This is not.
Counsel, I understood your beginning argument to be relying on apparent authority, because that seems to be in some ways an easier argument for you to be making than actual authority. And now I'm confused what the heck you are.
Well, Your Honor, I think the briefing takes a position that on these facts, that a jury could find either. I think that was ultimately our position all along. And the court has
if you have actual authority, who cares about apparent authority? You only get to apparent authority if there's no actual authority.
I agree, Your Honor. My point was that on these facts, in applying the considerations and the tests that were used in Barrett, which were used, Your Honor, in a case of apparent authority, And I think ultimately what the court was doing there was saying, look, if you have these facts, of course it's going to appear to the patient that this is a Banner doctor. It's going to appear that way. And in those circumstances that I can think of, would that be more important to consider than in the emergency room setting, where people don't have time to choose? They have no choice. And to allow a vague or even a clear, direct statement in an admittance form to somehow erase everything else the hospital did to create the appearance of authority, the appearance that he is a Banner doctor, would be an injustice. And I'll reserve the little time I have left for rebuttal, unless the court has further questions.
But we will.
I know. I know. Thank you.
Ms. Gilbride.
Good morning, Your Honors. Eileen Gilbride for Banner Health. Judge Howe, I'm confused too. There was a lot of shotgunning there, that some stuff that wasn't in the record. Let me try to, I don't want to fix what ain't broke. There is nothing in the record on actual authority. I don't know if they're actually relying on actual authority or not, but EPS determined his shifts, said he could work for others. They billed and collected the payments. They provided the malpractice insurance. They paid him an hourly rate. Banner didn't direct his care.
To the extent that I was unclear about where I am on that fence, I don't think actual authority is an issue here. On the
Okay.
record. So
Let's
you
go
move
to
the apparent.
Let's go to apparent authority. There is a test for apparent authority, and as Your Honor,
I should qualify. I speak only for myself.
understood.
Well, and what is, I too am interested in apparent authority.
Yes.
What is the test so that we can decide whether something is or is not apparent authority?
Yes, there's a two-part test. It's in Fidelity, as Your Honor knows. And the two parts are, A, the principal has to manifest to the third party that the doctor, or physician in this case, is an agent. And B, the patient has to justifiably rely on that manifestation. That's the test. It's set out in Fidelity. It's not a totality of the circumstances test.
Correct, it's intentionally or inadvertently.
That's correct.
So it's not manifesting, it's that there was an intentional or at least an inadvertent suggestion to a party.
Manifest, yes, exactly so.
And I am sympathetic to a degree with it because I've been there. If you're in an emergency room, you're not thinking, who am I going to hold ultimately liable if something goes wrong? You go to the emergency room, there was a doctor in a hospital. I would, without being educated, I would think, oh, the doctor works for the hospital.
But we don't determine apparent authority based on assumptions. Apparent authority is an element, it's basically an estoppel argument. Okay, the principal has to do, as you said, Judge, apparent authority doesn't exist unless there's no authority. Okay, there's no actual authority. Then we go to, okay, is there apparent authority because the principal misled the third person into thinking there was actual authority when there really wasn't? Okay, so the principal has to do something to mislead the third party into thinking that there was an actual agency, and the third party has to justifiably rely on that misrepresentation. It can be inadvertent, it can be intentional, but there has to be a reliance on something.
Let me tease out that inadvertent piece. I'm not trying to put arguments in, but I want to understand.
Right.
It seems like the inadvertence is, instead of saying these people won't be, or specifically saying, okay, let me see who your doctor is, let me tell you who your doctor is, and this person is or isn't, does the term generally, they are not, create a potential inadvertent suggestion of agency for some? So let's address that.
It does not. Because as Judge Perea, stated, generally means, and it stated, it listed the emergency physician as not being an agent or employee, and that the hospital was not liable for them. Let me contrast that to the Amick case, for example, where the physician was wearing a banner ID badge. Okay, and the
Which case was it again that you're talking about?
Amick. It's the unpublished, it's a mem decision, where the physician, he was not an emergency doctor, he was an on-call neurologist, I believe, or a surgeon, and he was wearing an ID badge. And there, the plaintiff said in their disclosure statement, we expect the patient to testify that she believed he was an employee. Now, I don't think a disclosure statement is enough, but the court didn't go there. And so the court found that there was an existence of an ID badge, and she was going to testify that she believed that he was an employee was enough to create a fact question on that issue. We don't have any of that here. We don't have any ID badge. We don't have any evidence of justifiable reliance.
So in a case where someone has passed away, what could they do to show the reasonable reliance? Is there anything? Are you saying that if the patient dies, that there's no way to prove an apparent agency case?
I mean, it could be that the person went to the hospital because that doctor, practiced there, and that relied on the fact that the doctor was there, or I don't know, what evidence they could bring forth besides the person's testimony. But I suppose there could be some indirect, some circumstantial evidence of justifiable reliance that certainly just isn't present in this case.
And just to be clear, in such a claim, who has the burden to prove those things?
Right, the plaintiff has the burden of proving agency always.
Okay, so then let's move just briefly, because we're not, I take Judge Howe's comment to heart, we're not a policymaking body.
Correct.
But you do concede there are jurisdictions where that's flipped on its head, right?
Yes, there are.
Illinois being one of them.
That's correct.
Okay, what does that mean to us?
Well, it means nothing to us today. I don't think it's going to mean anything to the Supreme Court, so assuming that it goes the way I hope it's going to go, and that they want to take this up and try to change the law in the Supreme Court. This court has already rejected that theory in Amick and in Fideli, saying that that's incorrect. And the Supreme Court already depublished that Henry case where Judge Ehrlich talked about kind of those factors. I mean, it doesn't mean anything to us today. Whether it means something to the Supreme Court, I suppose, is yet to be seen, but I have my opinion on where that's going to go if it goes that far. Is that what you were asking?
Yes, ma'am.
Yeah. I mean, honestly, I don't have anything else to argue. I don't want to repeat the briefs unless you have questions.
So what do we do with Barrett, which is this?
Yeah.
And I will say another piece of that will be what is, from my perspective, where we have blended this concept of employer and employee and actual agent. So many of our cases, especially in this area, talk about the doctor was an employee. Well, what they're saying is the doctor was an actual agent, from my perspective. And I'd like to hear your opinion on that. But then also on the fact that Barrett was this an apparent agency case, but didn't use the
Right.
test.
It was horribly misanalyzed, and I think it's incumbent upon the court to correct that misanalysis and to not perpetuate the blending of, its failure to actually analyze the actual authority and the apparent authority, and to sort of separate them and analyze them with each of their factors. I think it would be incumbent upon this court to perhaps, you can't overrule it, but you can say this is incorrectly analyzed, and we're not going to
So is it fair, and it seems to me, with actual authority, we don't look at what the patient's thinking. We're looking at the agreements, the relationship with the doctor. The patient doesn't know how much the hospital controls the doctor.
Right.
When we get into a parent, it's what is the patient saying? Is that
That's
fair way to express the difference?
part of it. It has to be based, what the patient reasonably, justifiably believes has to be based on the manifestation by the principal. So we can't just go on what people assume when they go to the hospital. I get it. You go to the hospital, you're in extremis. Maybe you don't even read the forms. You're just signing. But we're not arguing that apparent authority doesn't exist simply because she signed the form. We're arguing that apparent authority doesn't exist because there was no manifestation that he was an agent employee and no justifiable reliance on a manifestation.
You mean other than the fact that he was there and he was treating her inside of that facility?
The hospital simply existed and he simply was there treating her. That's all there is. And
I believe that council thinks that that's enough.
it's not enough. It's not in Arizona. It's not. It may be enough in those 12 jurisdictions that flip the burden of proof, and they allow you to assume agency simply from the fact that a hospital exists. That to me does not use a legal theory, that's akin to estoppel, which is what apparent agency is based on. That simply makes a policy decision that we're going to have, as you have said, hospitals just be, insurers of the treatment of these independent contractors. And that's not
a policy problem. His argument is who should be. Should it be the hospital or should it be the doctor that perhaps made the mistake?
Well, I mean, it's if the doctor made a mistake, it's going to be the doctor. Whether the hospital is added to that has to be based on a legal theory, not just a policy decision. That's for the legislature, if at all.
But when you flip the burden, the policy decision has been the hospital's going to be on the hook for that.
That's right. That's a policy decision that the legislature should make, if at all.
In fact, there have been efforts in that regard with regard to people who are not part of the network, right? There's laws now about hospitals and network doctors, and again, a policy issue down the street, not something we decided.
Down the street, that's correct. Unless you have other questions, I'll just ask you to affirm. Thank you very much.
Thank you, Ms. Gilbride. Mr. Champ. So let's start with this two-part test in Fadley. Why is that not the test that we're doing here? Well, actually, back up. Do you agree that the plaintiffs here have the burden of proving apparent agency?
I do believe that the burden is on the plaintiff. I don't believe that the defendant can rely on lack of information that they placed in the record in their defense to somehow become determinative of what existed. For example, the contract between EPS and Dr. Eister, or between EPS and Banner. They had an affirmative duty to produce those documents and turn them over. But the test in Fadley, Your Honor, and maybe I struggled because I didn't really consider it a test. It's like, well, you look at whether they did something to make the patient believe there was this agency relationship, and was it reasonable to rely on it? But it's an oversimplification, I think, of so many different circumstances. And then at that point, I think you do have to then look at, okay, well, what was the contract in Fadley? That was unequivocal. There was, and so the hospital in Fadley was unequivocal in disclaiming liability and disclaiming the potential that the physician might be an employee of the hospital. We don't have that here. And to simply say generally is good enough, I think would be problematic. I also fear sort of, well, what happens now if the court says, well, sure, an unequivocal would have been good enough and this wasn't. well, then Banner just changes its contracts, right? It's admittance paperwork, and we're back where we started. But I do believe for the purposes of this case, Banner's admittance documents do not unequivocally let and put the patient on notice that there is no relationship. And the reality is, when a person walks into an emergency room, they have no idea and no way of knowing, unless you tell them, that the doctor is not their responsibility and that doctor's actions is not their responsibility.
And they don't particularly care at that moment.
I'm sorry, Your Honor.
The patient doesn't particularly care at that moment.
You know, the decision to choose your ER facility, I think if the court the court should require that if you want to avoid the argument of an inadvertent manifestation to the public that this third party is actually, you know, your employee, then you take affirmative steps so that people have choice. Because what the free market does, Your Honors, is it then allows Honor Health to say, well, hey, they're now telling everyone that we don't employ our own doctors, and hey, you know, just so you know, you come to an ER facility, it's likely not going to be a Banner doctor, and we're not going to be on the hook. And Honor says, well, we can attract those patients here. And if it's publicly disseminated in that way, Honor Health, we can rely on Honor Health, for example, or Dignity Health to take a different stance. No, we're going to employ our own doctors. And therefore, you can trust not only the doctors, but our facility, our hospitals. But allowing the hospital to not affirmatively put the patient on notice doesn't ever give them the choice. When they make the decision to choose the hospital to go to, they're not on notice.
Let me just, and I know you're past your time, but you have used, did not unequivocally tell the patient and some other phrases, but the test isn't that. The test is, did the principal, the hospital, intentionally or inadvertently lead the party to believe, not unequivocally tell them that they're not. So it seems like you continue to argue for a different test than we have under Fadley.
Yeah, so I believe all of their actions are intentional, Your Honor. That's just my personal belief. I'm not here to preach, right? I believe that the failure to disclose is intentional. It is systematic and intentional in so that the patient doesn't choose another facility. So I do believe it's intentional, but I don't think you need to find that in order to find that, at least in this case, they failed inadvertently. And I hate giving them the credit that it was an inadvertent, because I think the choice of language is also intentional. These are sophisticated parties. They know what they're doing. They know how to write contracts, just the way the hospital did in Fadley. They knew how to be unequivocal so that there wasn't an inadvertence.
I was going to ask you to stop, because you have nothing in the record where you deposed anybody from the hospital. Where did this language come? So you keep making these statements. The best you have is inadvertent, right?
I agree with you that on this record, inadvertent is the best argument we have.
Thank you.
Thank you, Your Honors.
Thank you, counsel, for your arguments. We will take this matter under advisement and issue our decision in due course. The court is adjourned.
Thank you, Your Honors.